Yes.
May it please you, together with my own friend Mr. Archer, I represent the first appellant, local authority, in this matter. The second appellant is the child by her children's guardian and is represented by my own friends Mr. Andrew Bagchi, King's Counsel, Miss Emma Hudson. And the respondent mother is represented by my own friends Mr. Tyler, King's Counsel, and Mr. Barnes.
Yes.
Lords, this is an appeal against a case management decision of a circuit judge in West London Family Court on the 28th of May of this year.
Indeed. Before you get into your stride, can I just raise the question of anonymity, particularly important as the proceedings are being live streamed? Clearly the individual members of the family are entitled to anonymity, and if anybody inadvertently mentions their names or identifies them in the course of the hearing, both those who are in court and those who are watching the live stream must nevertheless maintain the anonymity of the individuals and not republish it, the names. What about the local authority? Has that been publicly identified in previous proceedings?
Well, there's no judgment published of the first instance decision, so as yet, no. I'm happy to retain references just to the local authority. Perhaps we can give some consideration between ourselves as to the way in which that matter might be dealt with ultimately by this court.
Well, hadn't we better decide it now? And is the local authority entitled to anonymity in order to prevent identification? Does it really identify the individuals if the local authority is mentioned by name?
Well, it's a wide authority. It's a London authority, and
yes.
And so to that extent, there are a number of people living within the authority. But I was going to avoid mention of the authority as well as mention of the residential assessment unit, just simply to err on the side of caution, and not out of any concerns for my client, but for the mother and her family.
A London Borough Council. Does anybody else want to say anything on this topic?
Well, not only there's no need, I don't think, for any of us to mention the name of the authority or the unit. However, there's a transparency order in the court below, which, as I understand it, allows for the name of the authority to be published.
Was the inquest published?
No.
No, inquest wasn't published.
Well, if there's a transparency order below allowing the local authority to be published, unless it's suggested we should interfere with that, then there is no harm if it is. Right. To the substance then. Yes.
Right, thank you. So the decision, the judgment is dated the 28th of May. My Lords, you have the order in the core bundle at page 259, and the particular paragraph refusing the local authority permission to pursue the findings relating to the deceased child's death. Paragraph 1 of that order, at page 262. Lord's permission for appeal was made on the applications were made both by the local authority and the children's guardian on the 2nd of June. Permission was granted by my Lord Justice Baker on the 4th of June on the basis there was a real prospect that both appellants would succeed in showing that the judge's decision not to hold a fact-finding hearing into the circumstances of the death of the elder child was wrong. My Lord directed the local authority to be the first appellant, the children's guardian to be the second appellant, and made further directions relating to evidence concerning the application for a stay, which ultimately was granted on the 6th of June. Lords, there are 3 bundles. There is the core bundle, which has 280 pages, electronically 282. So it'd be helpful at this point just to identify which the court would prefer, the number in the electronic or the page number on the type of page.
Well, we're not all reading from the same type of hymn sheet. I mean, I have hard copy. My Justice Peter Jackson has digital,
Hard copy.
and my Lord. So
Well,
anyway, what's the difference? I mean,
It's two. One adds- one
you
adds-
add two
Add
for
two
digital.
for the electronic.
You don't have to,
Yes.
to call it out every time. I can add two
Yes.
in my head, and probably it's different in the other bundles as
It
well.
is.
But
We'll manage.
Could I ask you something, having interrupted you, without identifying any geographical place? What's the situation of the mother and child at the moment?
Mother and child at the moment are in a mother and baby foster placement.
So that the suggestion was that it would be an 8-week period, and is that 8 weeks, as it were, running at the
Yes.
moment? Or
I think I have an update if I can just.
They're moving tomorrow, my lord.
To where?
So
From
they're-
the unit to the foster placement.
Yes, they're moving
it
on the
hasn't
9th.
started? I see. So they remained in the residential unit. They're there now, and they'll be moving tomorrow to the mother
Tomorrow.
baby foster placement, which is intended to be an 8-week
I think that's
placement.
8 weeks. Yes, my lord.
Thank you.
Yes.
The two other bundles, the supplementary bundle runs to 422 pages by permission of the court, and there's an authorities bundle of 119 pages. So the judgment is in the core bundle, and we have a transcript now of the submissions from 203 electronically, 201 on the page. Lords, the factual background is well traversed by the parties in their skeleton arguments. So with the court's permission, I would like, if I may, just in relation to the background, to begin with the position as it was at the hearing before the learned judge, and in particular the local authorities' revised threshold, which is in the supplementary bundle from page 218 electronically 222. And there the court will find the pleading of the local authority in respect of section 31 criteria.
I'm sorry, could you give me that page number again?
Yes, it's 218 on the page.
Supplementary.
Supplementary, please.
Thank you.
And in particular, at paragraph 3 of that document, page 219 on the page, the local authority asserts that the cause of the deceased child's injuries, which it sets out, and at paragraph 3, the subsequent, paragraph 3 and 4, the subsequent death, were due to the actions of the mother, and consequently the mother is likely, the subject child is likely to suffer significant physical harm. At the time the matter was before the circuit judge, there was no response to this document. There was a denial in an interim response to any suggestion of culpability in respect of the death, and we have that in the supplementary bundle on the page 191, 195.
Before we go away from that,
I'm sorry?
Before we go away from that, the remainder of the threshold document, from paragraph 7 onwards, it is found, is it, in the original pleading of the threshold?
It is, not as clearly as it is here, but it is referenced in the original document.
But that 7 to the end is what the local authority said at the outset of the proceedings,
Yes.
and this is its developed
Precisely so, Lord.
document. And so none of those features in 7 to the end was contingent upon any of the features found in 1 to 6. That was a freestanding pleading.
Quite so. The position of the mother, although she hadn't responded to the revised schedule, was clear. She had, in many respects, whilst admitting smoking cannabis while the child was in utero, the subject child, denied all other allegations, but in particular in relation to these allegations of causing harm to the deceased child and the deceased child's death, The first reference is the residential unit at 292 in the supplementary bundle, where the unit records between 292 and 293 paragraph 21.1.1 that the mother vehemently refutes concerns of professionals. She does not believe they are valid. For example, she asserts that the death of the child is being held against her. There's no risk to the subject child. In answer to, or in her interview with the psychiatrist, and this is at page 246 in the supplementary bundle, she explains that the mother explained to the psychiatrist that the child suffered, paragraph 205, suffered from a head injury. She does not know the source of this. She found him quickly, called an ambulance. She thinks something happened in the ambulance. And in our skeleton argument, we've identified the passages within the witness statement where again she refutes any wrongdoing. These can be found in the main bundle at page 107. Sorry, that's yes, 107 is where we've set it out, the summary, in our skeleton argument. We have that witness statement in the supplementary bundle, and in the supplementary bundle it's to be found at page 313 and following. We've taken the extracts from that document and set them out in our skeleton. So in particular, the mother highlighted to the court in her witness statement her ability to look after the subject child and to meet physical and emotional needs to a high standard. She was shocked to learn of the residential unit's recommendation for a mother and baby foster placement based on my apparent erratic presentation and emotional dysregulation, so she appeared to dispute that. And she made it even clearer, I don't think I was acting erratically or dysregulated in any way. So that was her position in relation to the allegations concerning the deceased child. But as Lord Justice Peter Jackson has identified, the local authority also pleaded matters relating to misuse of drugs, cannabis, and the mother's mental health.
Sorry, the paragraph 48 that you've been reading from is not to do with the child who died. This is to do with the assessment of her behaviour within the unit, isn't it?
Yes, but it's to do, precisely, but it is primarily to deal with her denial of emotional dysregulation.
Well, exactly, but the whole point of this appeal is as to whether there's a gap between those two concepts. So we cannot elide paragraph 48 with something that she says about the death of the child. You've taken us previously to things that she has said about that. But
yes.
That paragraph there is to do with her refusal to accept the professional opinion of what she's like.
Yes, I accept that. It does, however, certainly deal with the issue of her mental health, which I'm coming on to. And that is pleaded, as I say, in paragraph 7 to 9 of the revised threshold. And in relation to that and the misuse of cannabis, both of those were denied by the mother to the parenting assessment unit. And we see that at 282 in the supplementary bundle. Where at paragraph 15.1.9 the assessment reads that the mother did not engage in the substance misuse and mental health support programs as she's engaging with external support. However, when aspects of her mental health or substance misuse were explored by the lead assessor during the assessment, she felt it was not relevant to the parenting assessment. She asserted that the assessment is about her parenting and not her past. Thus, the effect of the judge's decision, paragraph 1 of the order under appeal, is to determine that the local authority can assert the risk to the subject child of physical and emotional harm due to the mother's poor mental health, in particular her propensity for aggression and her unpredictable behaviour. And the local authority can also assert the same as regards her misuse of cannabis, but the local authority cannot ask the court to consider how those same factors might have led to another child's death. In other words, the judge's decision is such as not to permit the local authority to seek to prove the most serious of the pleaded allegations, that is, physical injury leading to death. So the local authority may not seek to establish whether the serious injuries and or the cause of death have any impact, and if so, the extent of that impact on the viability, in particular the safety of the subject child being cared for by her mother.
Can I ask you about the points that you, I think, rightly say the judge left open to you to prove?
Yes.
Poor mental health, propensity to aggression, unpredictable behaviour and misuse of cannabis. As I understand it, but I'll just ask you whether you see it the same way. The judge's decision does not prevent the local authority from going back into history for however far it's relevant to do so in that. The evidence which was given, for example, by Dr. Van Velsen, draws upon evidence that had been prepared and given during the mother's own care proceedings. And so the court, leaving aside the child's death, has evidence on which it could choose to rely if it wanted to, which goes back for more than 10 years, doesn't it?
Yes, that's right.
So the effect of the decision was not artificially to say, well, the whole case begins in 2025. The evidence gathered now goes back a very long way.
Well, we would say that categorization of the judgment, in fact, highlights the artificial nature of the judge's direction to ring-fence the issue of the death, because one can go back through the history, as my Lord has indicated, and ask oneself whether or not there were signs of impulsive behaviour. But one may not ask oneself what were the consequences of that impulsive behaviour in respect.
But the question is surely not what were the consequences, but in the end the question is what would the consequences be of a person with this propensity, as you put it, being in proximity with a vulnerable infant.
Yes, but what would the consequences be must in turn depend upon what harm has been suffered in the past, what is the likelihood of that harm being suffered again. And one simply cannot begin to answer those questions in the way that we've identified in our skeleton argument in respect of the submissions concerning the Reed T case, if one artificially ring fences the death.
Well, so put it the other way. Let's suppose a trial took place in relation to the other child's death, and the court was not able to be satisfied that the mother had injured or killed the child. Would that leave the local authority without remedy to protect this child? Or would it not in fact be saying, here you have somebody who has poor mental health, propensity to aggression, unpredictable behaviour, and misuses cannabis?
It would be saying that, but it would be asking the court to consider the consequences for the subject child.
And it would be saying that could be very serious indeed.
Well, it may or may not. The mother...
Well, that's, of course, but
well,
they may.
It limits the local authority to saying to the court that that sort of behaviour tends to make the mother oppositional, tends to, this is on the current evidence, tends to make the mother prone to refuse to take advice. But that is a world apart from tending to give rise to a propensity to physically harm a child. It's a sea change, it's a step completely apart. And the question the local authority would, I suppose, ask rhetorically, why would a family court prohibit that inquiry when it is only going to give the court the clearest answer to the question of that it must ask itself under section 1(3)(e), what is the likely harm to be caused to the subject child? And that is why, in our submission, one has to consider that the learned judge ruled out the extent of, or ruled out the question of whether, and if so, the extent to which the mother was prone to impulsive behaviour when her first child was in her care. Whether, and if so, to what extent the mother was smoking cannabis at the time the child was in her care. The extent of whether, and if so, to what extent her mental health issues, her emotional difficulties were relevant to the death of that child in her care. And consequently closes down the potential for the court determining whether or not the impulsive behaviour of the mother towards the deceased child and her misuse of drugs and her mental health and emotional issues are relevant to the subject child, to the extent that that subject child might suffer very serious harm, if not death. The consequence is that for the subject child, none of those matters relating to the death of the older sibling can be explored when the court comes to consider the risk to this child. The mother's vulnerabilities were clear to the judge. He had, at the time, and by the time of his judgment, both the initial report of the psychiatrist, but also her addendum. And she identifies, for instance, at page 254, ongoing vulnerabilities at 283, paragraph 283, ongoing vulnerabilities in the mother's situation. She said the reality of what this looks like is not clear. She refers at the next paragraph to the instability, the disruption, the conflict, which could all trigger emotional instability. She raises her concerns about the mother's capacity at paragraph 292 on the next page to mentalise, to be attuned to the thoughts and feelings of others. She considers that could be reduced if the mother becomes aroused or preoccupied by feelings of being unfairly treated. Well, those matters in and of themselves are of concern, but they're of particular concern if they might have given rise to the death of a child previously. The parenting assessment, written in the light of the first psychiatric report, at page 280, identified how the mother struggles to mentalise, how she quickly reaches deadlock, quickly becomes emotionally dysregulated, and how she'd been volatile throughout.
I'm sorry, which paragraph were you reading from then?
Sorry? 15.1.1, my lord.
I'm sorry, Mr. Toomey, thank you.
And then at page 282, 15.1.9, during the assessment, she did not engage when aspects of her mental health or substance misuse were explored by the lead assessor. I've taken my notes for that. 15.1.11, mother struggles immensely in working openly, honestly, and collaboratively with professionals. And at page 292 to 3, 21.1.1, she lacks insight and vehemently refutes concerns, including risk from the death of her first child. Now, if all or any of those vulnerabilities were present when the first child died, and if they played any role in the death of that child, then the fact of the gravity of the injuries and cause of death must be highly material to the risk to the subject child from the mother and the viability of placement of that child with the mother.
But isn't it very clear from reading the information before the court as a whole, when you say if those vulnerabilities were present at the time of the child's death, they were. These are not mobile features. These are static features of the mother's presentation. No if about it.
They were my lord, they were certainly present. They were there. The whether, and if so, to what extent, any one of them or any combination of them, of those risk factors, cause the death of a child, is undetermined.
Yes, and I mean, having read the coroner's inquest, what encouragement could the judge have taken to think that hearing all the previous experts, hearing 2 or 3 new experts, and then hearing from the mother and the mother's grandmother and whoever else was heard from, was going to shine any light at all on those questions that you just indicated?
Well, that would be a matter for the judge in his case management powers.
Yes, but the judge is in the cockpit in this case of understanding what the probabilities were for each forensic step. I mean, I'm asking you this rhetorically. What prospect is there of the court in a year's time, by which time goodness knows what would have happened, in a year's time be in a better position to understand these historic events? Mother isn't going to depart from her position of deflect and counterattack. The family isn't going to give any more information than it gave at the time. What's the product of that?
Well, the product is that the court makes a decision as to what happened and, insofar as it can, why it happened. So the first question, what happened, the court might find that the mother is not culpable for the death of the child, or the court might find that the mother is culpable for the death of the child. And in that latter scenario, the court will go on, insofar as it can, to determine why the mother acted as she did. And if it cannot so determine, having determined that she did act in that way, and having found, therefore, the threshold criteria established, would be guided by the subsequent risk assessment, and the risk assessor would, of course, undertake, insofar as they could, an assessment of why the facts proven had happened. And that would then inform the court, both in relation to its statutory obligation under Section 1 to consider the likely harm to the subject child, but also in its consideration of the care plan under Section 31(3)(b), where it's obliged to consider the risk of harm to the subject child.
judge's approach was to take your case at its highest, to accept that it was a solid case,
Yeah.
and saying, having done that, to find that the process that you've just described is circular, that it really ends up back on the sort of pages we've been looking at.
Well, I can't, my lord, accept that it's circular if there are two potential routes out. The two potential routes, she did it, she did not do it. Those are...
Accepting your case up to its fullest.
Well, he can't do that, and he can't do that because there hasn't been a finding. He cannot find that the mother... He has to find whether the mother did it or she didn't do it, and that's the re-B point and the re-H point that flows from that.
But in order to decide whether to embark upon this extremely heavyweight process, doesn't he have to decide what the likely product of that is?
Yes.
In terms of his ability or the ability of a
Yes.
colleague judge?
And that's where he
Assess
fell
risk.
into... That's where we say he fell into error, because when he came on to consider that, what he first of all considered is that he should not take account of the consequences of the impulsivity. He said that he should not take account of the impulsivity potentially causing the death of the child. He couldn't see how that elevated, and I'll take my lords through the relevant passages. He could not see how that elevated the risk to the subject child.
I don't think I agree with what you're describing him as having said, but we'll come to that.
Certainly. So this may be then an appropriate point to consider the legal principles. But just before I do, the local authority contends that the culpability of a parent for the death of a child, if proved, must always be relevant to some extent to the safety of another child in their care. And so pausing there, for instance, if this child had died with a sibling, can be no serious doubt but that there would have been care proceedings in respect of that sibling and a fact-finding inquiry in relation to the death at that time. In this case, there's the striking similarity of the subject child being of a similar age to the deceased child at the time that child died, in the care of a mother who continues to misuse cannabis, who continues to be quick to aggression and have some emotional or mental health problems, seeking to take her child either into her primary care or certainly into the type of family arrangement where the first child died. And yet the judge has ruled that we cannot look at what happened to that child who died when all of those features were present, when deciding whether or not the subject child can be safe in the mother's care.
What's being put to you, I think, is that given that those factors are still there, then there is no appreciable benefit or additional benefit from having the fact-finding hearing to determine whether or not the child was, the death of the child was caused by the mother. It's all there in what you've already got. What does a factual finding add to the evaluation of risk in this case?
Well, I think the answer to that question lies in the what we've said in our submissions about VT and the assessment of risk, which we've set out in the skeleton argument at paragraph 29 in the core bundle, page 98. Of course, the judgment of my Lord Justice Jackson, and at paragraph, we've replicated this in the skeleton, paragraph 33, having identified the requirement to establish harm or likely harm. Accordingly, the court has to address these questions in relation to each of the children. What type of harm has arisen?
I've got the paragraph. It's paragraph 29 on page 98. Thank you.
Thank you. What type of harm has arisen and might arise? What type of harm, how likely is it to arise? what would be the consequences for the child if it did? To what extent might the risks be reduced or managed? And so we've addressed those questions at page 101.
Could we stay with just the list for the moment?
Yes.
With which of those assessments are you hampered by the judge's ruling?
Well, certainly those that I've read out. So what type of harm has arisen?
What you say, all four?
Yes. Because if you can't answer the first question, what type of harm has arisen?
Well, he can answer it. The answer is no harm.
Well, as things stand.
The answer is, on the basis of the judge's finding, you proceed on the basis that the child's death was not caused by the mother.
Exactly.
Well, wait on. We're talking under one about the child with which we're concerned, and nobody is suggesting that any harm has come to her. No doubt, account can be taken there of the circumstances in which she's been living, but your case is not a case of actual harm to that child.
It's
the second limb.
It's section 1.3e, which is harm or likely harm. It's the same subsection.
It's the harm that might arise, is the, or it's likely to arise.
Likely harm, yes.
So we're not concerned at the moment with what harm has arisen. We're concerned with what harm might arise to this child,
yes,
as a consequence of a panoply of matters, including the death of the half
Yes.
sibling.
Absolutely.
So I was trying to ask you to be as analytical as you can be about those 1, 2, 3, and 4. Which parts of those are problematic for you in the light of the judge's reasoning?
All of them. Because what we cannot do is, considering this child, subject child, answer the question in relation to likely harm by reference to the death of the deceased child. So we cannot say to the court that this mother has such difficulties, has had such difficulties, that they have led to the death of a child. And therefore we cannot begin to say whether or not that is likely to arise in the future, because it is not established. And in our submission, that means that, and we, as I say, we addressed the issues on page 101, paragraph 37. What type of harm has arisen and might arise? So by the judge's decision, no account can be taken of any harm suffered by the deceased child. Similarly, the court cannot ask whether the type of harm, including death, might arise in this child's case. And that issue has been summarily excluded from consideration. Indeed, the judge, we say, appears to have regarded the previous harm as irrelevant, and there we cite from the judgment, paragraph 30, he says, does this approach wrongly look, that's the local authority's approach, at the outcome of the identified risk rather than the risk itself? Is the risk under consideration the impulsive behaviour, not the suggested shaking? And is any risk assessment moving forwards managing the same, rather than a focus on preventing a further risk of shaking? And he approves that approach. I consider and agree with those acting for the mother that risk planning is focused on what it is that causes risk. So we say that's plainly wrong, because he's not looking at the consequences for the child who died of the risk, whatever the risk was, if the child was, if the death was the result of the mother's actions. He's not looking at that. So he's excluding any consideration. Question 1, what type of harm has arisen? And therefore, we go on to explain why it is he can't answer the subsequent questions. And this really should begin this passage really should begin with consideration of the well-established, well-known judgment of Lord Hoffman in Re B. The Lords have that in the authorities bundle at from page 3. And in particular, paragraph 2 of that judgment.
You haven't put Re H in the bundle.
We haven't, although in fact, in many respects, that's more
Yes.
on review, more.
Well, Re B, what Lord Hoffman said in the first few lines of Re B is
Yes.
really built on, I think it's what Lord Nichols said long ago now,
Yes.
nearly 30 years ago, in Re H, isn't it?
Yes, so Lord Nichols gives the majority decision in Re H, and the references he makes, Lord Hoffman makes, to Lords Brown, Wilkinson and Lloyd are references therefore to the minority decision. And the consequence of Re B is just to reiterate what was said in Re H, namely that a finding of present harm has to be based on facts, just as a finding of future harm has to be based on facts.
But it's a question of how you define facts. If the fact is that somebody is impulsive and does things without regard to the impact on people around her, won't take advice and so forth, that's a fact, isn't it?
Yes, but it's equally a fact that the consequence of not taking advice might be that the mother chooses to give the child a dummy when the health visitor says she shouldn't have a dummy, or might mean that the mother, in an example, not necessarily this case, puts the child at extreme risk of danger. And one has to therefore ask oneself, is that likely, the former or the latter? And if there is a good example of the latter, then it surely informs the assessment of risk to know that the mother has so behaved. In other words, impulsivity is one thing. What it gives rise to, or in this case, what it has given rise to, is quite a separate thing. And it's essential for the proper assessment of risk to understand what has happened. And the passage I refer to from Re B, it's the line in paragraph 2, there is no room for a finding that it might have happened. So we say that's precisely what this judge has done in the course of the judgment. He's looked at what might have happened and endorsed a risk assessment on that basis, at least in certain parts of the judgment. And it's not entirely clear, I suggest. But the point of Re B, as I say, is to make it clear that the assessment of a finding of future harm must be based on facts. And I accept what you say, it depends what those facts are, but it is a critical fact that a child died in this mother's care, and it cannot be overlooked, and it must be front and central to
Why
any
do you
risk
say the
assessment.
judge made a finding that it might have happened? He didn't make any finding at all.
Well, he's asked. I mean, perhaps I can turn to the
He's
the
done
judgment.
a different exercise, which is that he's done what. I mean, your argument would seem to lead to the conclusion that every time a child dies, there's always got to be a fact-finding hearing.
No, I don't say that. What I say is that every time
No,
a
but
child...
I don't know what harder facts one could provide. That there's got to be an evaluation of what the value is
Yes.
of a fact-finding hearing.
Yeah.
And so the judge was not making a finding, as it seems to me, that something might have happened. What he was doing is he was considering your argument, making an assumption in your favour, and then seeing where that led him. I appreciate you have an argument about that. But
Yes.
I don't see at the moment that he can be charged with having made a might have finding. That's maybe not your intention.
It is certainly a proper task or a proper route for a judge to say, so what? We have this fact-finding. Where does that take me? He's required to do that because he can't answer the question as to whether it's necessary or not. So he certainly, that process of asking himself that question is a proper process. I don't criticise him for that. But what we do criticise him for is undertaking that process and firstly ruling out the prospect of a determination relating to the death when it's such a significant matter for the assessment of risk for the subject child. But we do criticise him for the way in which he addresses the issue, which perhaps at this stage I can identify what we say about the judgment in more detail by reference to it. In parts we say there's an assumption as to what might have happened, which in effect amounts to the mini-trial, which the judge said he was not undertaking. There's an assumption of a factual matrix in the determination of that mini-trial, which was not open to the judge to make. It rules out examination of the details of what happened and why. And it rules out the real possibility that the judge, upon hearing the case, can determine both what happened and why, or if not, that a subsequent risk assessment can determine why something happened. So, turning to the judgment then, at paragraph 27, which is at page 272, at the top of 273, excuse me, the judge says this in the second line: a finding which would or be likely to identify an existing and continuing risk of a material significant nature, and which, without fact-finding determination, could not be properly brought into the process of risk assessment, will, in my assessment, almost always require adjudication by way of fact-finding. We agree.
Forgive me, I'm so sorry, Mr. Toomey. I didn't quite catch where you were reading from.
You're at the top of page 273.
Thank you very much.
Which is paragraph 27 of the judgment.
I'm sorry to interrupt you.
So that is something we agree with, and we say he's asked the right question, but he hasn't answered it correctly. And we contend that he thinks, or thought, that a risk assessment could take account of a suspicion, not a proven fact.
Where do you get that from?
Well, I'm going to come on to that. Or that he thinks that the facts, if proved, would make no difference to a risk assessment. But of course, nothing had been admitted. There will need to be a fact-finding inquiry as part of the court's process, because nothing has been of a substance has been admitted. And of course, we say he ignores the outcome of the risk to the deceased child. So one moves on then to paragraph 30. So paragraph 29, he addresses the local authority submission.
Do you accept that the question in the first sentence of 28 is a correct question to ask?
Yes, that is a correct question. Then sets out the local authorities case at 29. And then at 30, the mother's case, which he ultimately approves. In this way, second sentence, does this approach, that is the local authorities approach, wrongly look at the outcome of the identified risk rather than the risk itself? Is the risk not the impulsive behaviour, and not the shaking. And he goes on to say, and is any risk assessment the means and route towards managing the same, rather than a focus on preventing a further risk of shaking? In this context, is it relevant or helpful to become fixated on how circumstances might play out in the event of an impulsive action? Which he then goes on, by its very nature, the outcome of the same is bound to be unpredictable. And at the close of that paragraph on the next page, the mother's submission is to acknowledge that a finding of impulsivity by its nature requires risk assessment when considering the care of a young child.
Could you give paragraph numbers?
Paragraph 30, top of page
Thank you very much.
274.
The last sentence of
Last
paragraph
sentence.
30. And this submission, so I'm following, this submission was ultimately accepted by the judge,
This
was
is
it?
accepted, my lord, yes.
That is really
This is-
his reasoning.
It is, yes. So to return then to that first passage in paragraph 30, the outcome of the identified risk. Well, what is the identified risk? How can there be an identified risk without a fact-finding? Because the court has not inquired into whether or not A, something was done, and B, which of the various permutations of risk were in play when that thing was done, if it's proved. So the identified risk is presumed in this paragraph, and he cannot presume it without a fact-finding hearing.
How would you define the presumed identified risk? His presumption.
Well, it comes, I think it's fair to say that in his judgment, that it comes under the umbrella heading of impulsivity or loss of control.
The consequences of
What we don't know are the triggers.
Well, so he is proceeding on the basis of of consequences of impulsivity, is he?
Yes.
That's a rather inelegant question. Do you follow what I'm trying to put to you? Is there a? I'll try again. Is there a presumption inherent in his judgment as to the consequences of impulsivity? That they could include the death of a child.
Well, he does seem to consider that all potential consequences should be considered in the risk assessment.
open-ended.
Open-ended, and of course the difficulty with that, just to take an example, there are many parents who might suffer from impulsive behaviour, but their impulsive behaviour might result in extremely low-level, not particularly harmful consequences. Would one, assessing such a parent, nonetheless have to say, well, look, we've got impulsive behaviour. That impulsive behaviour might lead to the death of a child.
Well, will the assessors in this case necessarily proceed on that assumption, that the mother's impulsivity could result in the death of a child?
As things stand, they can't. As things stand, they can only address the impulsivity and the consequences of it that are established.
Why do you say they can't?
Because the court has determined that cause of death is not to be established.
The judge seems to be proceeding on the basis that they could proceed on that basis.
Well, in that
I may
case,
be wrong about
well, he might be, but in that case, that brings me to the point about suspicion, because there are other aspects of the judgment, and I think particularly 35 and 43A of the judgment, where the judge suggests that risk can be assessed on the basis of suspicion rather than established facts.
Was it conceded on behalf of the mother that the judge could properly proceed on the basis that the mother's impulsivity could result in the death of the child, of a child?
I may just check, I don't believe so. No, it wasn't. No. No. Well, and indeed, it's right to say, my lord, that the court will remember at the outset I took the court to her witness statement, where she entirely rejects impulsivity or matters akin to impulsivity in response to the local authorities and in particular the residential unit's criticism of her.
If it was an agreed basis that between all parties, that the mother's impulsivity could result in the death of a child, what do you then say about the necessity of a fact-finding hearing?
Well, that would certainly be relevant to whether or not it was necessary. I agree, but whether it would determine the matter, whether it would determine the need for a fact-finding hearing or not, would depend on all the factors.
Yes.
But obviously, A, we're not in that position. B, if we were, I say it would depend. I mean, apart from anything else, all of this is very difficult for the person carrying out the risk assessment.
Well, what was said, but we have some assessments in them.
We do, yes.
Was there any, what was said about the risk before those assessments were carried out?
Well, one of the points relates to the residential unit's conclusions and whether, I think it's one of our grounds, whether the judge wrongly categorised the residential unit's approach to risk.
Yes.
And I'll just find the reference. There is.
I don't want to take you out of your way, Mr.
No, there is. Yeah, so it's in the supplementary bundle, page 296. And these are the concluding paragraphs under the question at 21.7 about support and safety planning, timescales, meaningful change and willingness to engage of the mother. And at paragraph 21.7.2, the author says, I must consider the possibility that the court may direct a finding of fact, and in which case this will be anxiety-provoking for the mother. Then goes on at 21.7.3, I respectfully recommend that as there are so many factors to consider and outstanding issues in this case, the safest placement option would be a mother and baby foster placement until the court makes further directions. So we say clear from this that the author of this report, knowing that the court may or may not direct a fact-finding hearing, can go only so far. And so this is the extent to which the assessment has proceeded. There is potentially to be a fact-finding hearing. That's for the judge to decide. At this point, we suggest this safe option. So we say that that indicates the difficulty for any risk assessment in not knowing whether or not there is culpability for the death. And that's where the case got to, or had got to. The second point about paragraph 30 is, and I say that the court cannot ignore the outcome, but he's expressly invited by the mother so to do.
It's not. My lord has already alighted on this last sentence. He's not saying one ignores the outcome. He's saying that one takes into account all outcomes. Surely. But the driver is the assessment of the risk with all outcomes in mind.
Well, one cannot read this paragraph without beginning at the start to read him say how the mother submitted that the approach was wrong because it looks at the outcome of the identified risk rather than the risk itself. I mean, that was the submission. Don't look at the outcome. The mother, you may, I mean, this is, of course, all off instructions. This is not a mother who is saying, I have these problems. So this is, as it were, reading between the lines and asking the judge to say, well, she may well have these problems because they've been identified by professionals. So let's just assume that she has these problems and let's just deal with those problems. But let's not consider what the consequences of those problems have been in the past, because that is out of bounds. That is the outcome. And that's where we say the judge went wrong.
You're suggesting paragraph 30 says that consideration of an outcome of maximum seriousness is out of bounds.
Yes.
That's your submission about that paragraph.
Yes, it is, because that is what he was invited so to do by the mother. And in our submission, no, there are 2 points. He could not invite any assessment on the basis that the mother might have such difficulties as to be culpable for the death and serious injuries caused to the child. So a risk assessor cannot take account of that. And the risk assessor must therefore simply say that this is a possibility. In other words, it's a suspicion.
I'm only saying they're not the same thing. That's
Well,
possibility and a suspicion. But if you're talking about risk, that a certain sort of behaviour may lead to all sorts of outcomes.
yes.
And the fact that you don't know which outcome it's going to be doesn't mean that you're acting on suspicion. You're acting on common sense.
No, well, exactly. And common sense really dictates that, my lords, that the judge, the court, goes through precisely the question and answers that my lord posed in Re T. What type of harm has arisen and might arise? And the harm to the other child was very serious, grave injury and death. And this judgment, by the court's direction, excludes that harm.
What else do we need to focus on in the judgment?
Thank you. Paragraph 32. The end of the paragraph, having looked at another case, HW, concludes there are very strong grounds for holding that any finding in this case would likely recognise the event as being one of temporary loss of control. Well, just for a moment, if that's right, is it not essential to understand why there was a temporary loss of control? The court still needs to decide whether what happened, the court still needs to decide what happened to know if death and serious injury were consequences of the mother's loss of self-control. Still needs to decide, either as part of a fact-finding or risk assessment post-facts found, what it was that gave rise to the behaviour, be it a loss of control or whatever, be it drug misuse, mental health problems, personality issues, and whether those factors remain, and if so, to what extent. But it cannot assume an outcome, loss of control, on the basis of facts yet to be tested. It would be unfair to assume that the mother was culpable for the death of that child without a fact-finding. It's equally unfair on the subject child and the local authority seeking to prove its facts to assume a cause or causes for the actions without a trial. Paragraph 33 he identifies how he should not undertake a mini-trial, and then says this in the second sentence: I have proceeded above on the basis that a finding were made, but within a likely context, of a loss of control in the moment rather than a more sustained or malicious act. So just pausing down, that is a difficult sentence. Is he there saying that it's likely that this happened as a result of a loss of control in the moment? Or is he saying that if it happened, then that is likely what has occurred? Well, if it's the former, he cannot do that because he's not undertaken a fact find. And if it's the latter, he cannot make assumptions as to what has happened or what might have happened. So this is a problematic part of the judgment. He goes on to say, I do not consider this to amount to a quasi-mini-trial, given it appears to reflect entirely the issues of risk before me by those seeking a fact-finding. But it doesn't. If there was a loss of control, are we now to presume that the mother was culpable? If we don't know the circumstances relating to a loss of control, how are we to know whether they might occur again? Or how are we to know what might be put in place to prevent them occurring again? Or might it be said that now she's matured and things have changed, that those aspects which have changed mean that the risk of it recurring are less? In other words, whatever caused it previously has now ameliorated and lessened. Her psychiatric assessment, of course, is based upon facts established in the medical records. It's not based upon culpability for this. And how does one answer the question whether it's likely to rise again if either it didn't happen or it happened on a presumed basis? How does any assessor deal with this presumed basis? How, for instance, if the mother says, as is extremely likely, I am not responsible, I do not have this tendency to act impulsively. Indeed, I deny all of the underlying factors that might make me prone to act impulsively. How is the risk assessor to address risk in those circumstances without a prior finding as to what had happened as a result of those underlying conditions and concerns? And then one can see at paragraph 34, second sentence, I have taken the view that it's better to proceed on the assumption that the local authority will make out a case of the mother being responsible for the matters alleged, although I've caveated it in the matter set out above.
Is he suggesting that all professionals thereafter should work on the same assumption?
Well, that my lord, is a good question.
Thank you. What's the answer? No, but it's a. I don't. What is the answer?
Well, the answer is it's difficult to know because there are two potential answers to the question. Well, one is.
Can you give the answers by reference to the judgment? How does he deal with it?
Well, it's in relation to that passage. It might mean they will prove the case, but I'm not going to let them. I'm going to assume it's true. I'm going to assume there's a loss of control. I'm not going to find anything else about the loss of control. And I'm not going to allow risk to be assessed on the basis that this happened, or that this is likely what happened, and so a fact finding is unnecessary.
Well, you said that. Can we just go through the judgment and identify what his answer to my question was, in his words? In other words, my question is, was he proceed on the basis that thereafter, after, professionals would proceed on the same assumption?
So paragraph 35, the third sentence, but I do not. But I do not understand why those working in such a setting, and that's those assessing the mother, would be unable to bring into their care and safety planning the prospect of a range of risk outcomes, including that which would be subject to fact-finding.
Is your submission that he's answering my question yes?
Yes. At that point. And then he goes on, I consider and agree with those acting for the mother that the risk planning is focused on what it is that causes risk. The question of how that may play out should not be limited to those outcomes which have been established to have previously arisen as a result. And there the answer might be no. The answer might be no there, because what has been established to have been previously arisen cannot be the death and cause of death, because he's ruling that out. And so, and that ties in with what he's saying. In other words, we're looking at the impulsive behaviour rather than the consequences of it.
I think the answer, sorry, forgive me, I think the answer is yes. I think it's yes again, because what he's saying is the question of how that might play out should not be limited to findings that are made. So I think he is actually answering that's yes as well. I don't think there's a, that's why I wanted you to go through this. I think my reading of this was he was proposing that everybody should proceed on the same basis, on the same assumption.
I can see that. It's just the reference to outcomes, and again the judge saying that one should not be limited to outcomes. I think that must be right.
Any risk planning will be short-sighted in the extreme. Yeah. And that must mean that if you didn't take into account all the possible risk outcomes, it would be short-sighted.
Yes. Well, that certainly returns to yes. I think, my Lord, I have to agree that it's yes, yes, yes.
And why do you say he was wrong?
Well, because those facts have not been established. That those facts relating to the death have not been established. So outcome has not been established as a fact. How likely that outcome is to recur has not been established or cannot be assessed. And the extent to which any of the risk factors which are known about or which might have prevailed at the time of the death, the extent to which those were relevant has not been established. So how can a risk assessor even begin to assess risk without A, knowing whether this happened, it might have happened, or it might happen in the future? There's a sea check, there's a world of difference between something that has happened.
Yes, but you see, and this may be and let's park the case law for a moment, because it could be said this case ultimately comes back to re-H and re-B. But if we park that for a moment and think about how risk is assessed in life generally,
yes,
what we all do when we're assessing risk generally for our own children or grandchildren or whatever, is we don't make a finding. We don't proceed on a basis of finding. We think of the possible outcomes. We evaluate what the likelihood is of those outcomes and proceed to make our decisions accordingly.
Yes, but there are certain risks and there are certain facts in issue which have to be determined, which is why we have fact-finding hearings ahead of welfare hearings in some cases, where the risk is so significant that it dominates the landscape of the risk assessment. And this is one of these cases. A child has died. We don't know why, and we don't know how. But to even begin to undertake a risk assessment that is predicated upon the mother potentially being responsible is impermissible, because it's not been found. It needs to be established, and only if it's established can it be said that there are risks flowing from those established facts.
Do you say that the first sentence of paragraph 34 is simply wrong? I've taken the view it's better to proceed on the assumption the local authority will make out a case for the mother being responsible.
Yes.
You say there are only three possibilities. One is that there is a fact-finding hearing and it's found more likely than not she caused the previous death.
Yeah.
Second possibility is there's a fact-finding hearing at which, as I understand it, the judge is not allowed to say, I think it's 40% likely. It's either 51 or nothing.
Yes.
And the third is that there's no fact-finding hearing, in which case you're saying the judge has to proceed on the basis that she didn't do it.
Quite so. That's the binary system.
You say that's the consequence of Lord Hoffman's reductionist approach to re-age.
Exactly. So, and no one would criticise the mother for vehemently making those submissions, because she would be right.
At paragraph 34, actually what the judge is doing at that stage is to say that for purposes of making my decision as to whether there should be a fact-finding hearing, I'm making an assumption in your favour in order to test what the consequences are. Paragraph 35 is different in that he goes on to consider what the scope of the court's own assessment and the scope of other people's assessments is going to be consequent on that approach. But are you saying that it's inappropriate for the judge to have considered various hypotheticals and chosen the one that he found the most helpful when deciding this case management issue?
Well, no, I entirely accept that in determining whether or not there's a necessity for a fact-finding, he has to ask himself what the potential outcomes are.
And permute the fact,
Yes.
Permute the situations to consider that question. Absolutely. So your complaint is not essentially about that assessment or that assumption. Your case is that even though the judge thought you would be able to refer to all possible outcomes, that was improper. Is that what you're saying?
Well, certainly, having identified that we had the local authority as a strong case to prove that this mother is culpable for the injuries and death of her child, to summarily rule out of bounds an inquiry into why that might have happened must be wrong.
So can you contemplate a case in which a child has died a number of years previously in which it would be not mandatory to hold a fact-finding hearing?
Well, I certainly don't rule that out.
No, but I'm putting to you that it seems that the consequence of your analysis is that in any case where there is an unexplained but suspicious child death, the family court is obliged to go through the process for what it might show for the risk assessment.
Yes, because the death of any child in the care of a parent, where that parent may be culpable, will always be relevant to the question of future risk. Whether or not there's a need for a fact-finding hearing in the circumstance of a particular case will depend on all the factors.
Yeah, well, rather than, I mean, we can always retreat to all the facts of the case, but I'm talking about the real world that we inhabit. I'm putting to you that your submission would seem to lead to the prospect that unless one could come up with some very odd circumstances, the assessment of risk of a parent whose child has died in suspicious circumstances must always lead to an investigation by the family court of the circumstances.
I mean, I can give an example. So there may be, for instance, other overwhelming reasons why the parent cannot care for the child. The parent is not in a position because of, let us say, drug addiction. In that situation, why would one need to ascertain whether or not a child...
Right. So, but in any case where the parent was a runner, you'd have to investigate.
in any case where the parent was a runner, you undertake the assessment in line with the authorities, one of which is the necessity. I'm not submitting either myself or upon invitation of the court that it must always follow that there would be a fact finding. I've just given my lord an example where it would not follow. I will think about the example of a parent who is in the running, but what I do say is that, well, I suppose, for example, a child might die as a result of, might have died as a result of reckless driving. And a parent might be in a position where they're not able to drive a car anymore.
Or if a child, an older child, was returned to the care of a parent who had allegedly injured a younger child.
And there the risk matrix might be very different. So you might have a classic child who dies as a result of a shaking injury, and the question is whether or not the 15-year-old should go and live with the parent who had done that, or might have done that.
Or, yes.
I mean, there have been cases where this court has said it's not necessary. But those are often, almost always, cases where there are significant concessions in relation to threshold. So as I say, this court, the family court, will be investigating the other allegations made by the local authority. There'll have to be a fact find. And that's because there are no concessions. But what it won't be able to do is to say, as a result of any facts it establishes, that the serious consequences for the subject child could extend to death or serious injury, because they have in the past. And any suggestion that they could in the future would be entirely supposition. It would be based on nothing. It would be based...
Could it be said that the whole inquiry in this case is in fact brought about because of the death of the child? Is that really the real reason why the local authority are involved at all? And or is it? Would this be a case where this sort of inquiry would be being conducted in any event?
Well, it's difficult to get beyond the death because it is inextricably linked to the history of the mother herself being known to social services as a child, being looked after herself in the latter stages of her childhood, and all that has been known about her since.
To what extent was there evidence, apart from the death of the child, to what extent is there anything to suggest that the impulsivity which has been detected would be such as to impinge upon a child's welfare? Well,
that's minimal, I suggest.
Why do you suggest that?
Well, because the welfare upon which it would impinge relates to the refusal to accept instruction or direction. There's no example of the mother, as it were, putting the child in the way of danger.
A child or the subject child?
The subject child. But being advised, for example, about where the child should sleep and how the child should sleep, not being prepared to take advice and having to be told again. So it's relatively low level on the facts, which is why the other facts are so significant. And that's why I say if you had a given parent who is known to have impulsive behaviour, but it's relatively low level outcome for the child in their care, and has always been, then how could one ever, for instance, suggest that child should be removed permanently from that mother's care?
How are the assessors, maybe this is a question for Mr. Tyler rather than you, but what's your answer to this? How are the assessors to approach the whole question of the impact of the mother's perceived impulsivity on her capacity to care for this child if they ignore everything that's happened in the past? I mean, by which I mean the circumstances of the death of...
Well, in our submission, they can't. They just can't do it. I mean, there are cases where, pending a fact-finding outcome, one has an either-or. Those are difficult enough, but at least one can begin to explore those factors. But that's not this case. This case is predicated upon the here and now, with an eye to what's happened in the past. So if she is found to be impulsive now, then obviously her history is relevant, but the extent to which that history gives rise to a risk, one cannot begin to assess it without first determining whether that has been the trigger, the cause of a child's death.
Is the answer to the question from Justice Peter Jackson? He asked, do you say that in any case where there's an unexplained but suspicious death of an earlier child, family, there must always be a fact-finding hearing? Is your answer yes, if the outcome of the fact-finding hearing might realistically affect what is to happen to the surviving child?
Yes, my lord. Thank you. And then I think just in relation to this reasoning, at the conclusion of his judgment, paragraph 43, page 279, subparagraph A, this is the judge really summarising where he got to. He concludes that paragraph. Thus, the real question is not what may have happened on one occasion and then planning to prevent that, but asking what in principle could happen and creating a plan to guard against a range of risks. And that, of course, is to ignore what has happened and to proceed either on possibilities or, put another way, on suspicions. The question is indeed what may have happened. The question is what happened. The questions are what happened, why did it happen? In the light of the answers to those questions, is it likely to happen again? And the answer to that question, can the likelihood of it happening again be ameliorated in some respect by careful planning around risk? And to go on to answer those re-T questions. I mean, I've concentrated for the purposes of my oral submissions on the management, the issue of risk and the judge's approach to it. We make other complaints in our skeleton argument in relation to the judge's approach to the interests of justice and question of a fair trial.
Were they really material to his decision?
They, in our submission, are not material, but he having, we say, erred in relation to those matters, we've complained about them. But unless the court would be assisted by me sending you any detail in relation to those, and subject to checking my instructions, I think those would be my submission. Unless I can assist the court further.
Yes.
May it please you, my lords. There is, as you will have detected, a significant degree of overlap between the grounds advanced on behalf of the children's guardian and those advanced on behalf of the local authority. And indeed, many of the points alluded to in the skeleton argument advanced on behalf of the local authority are indeed made separately in our document.
Well, of course, there's no need you to repeat anything that Mr. Toomey has said.
May I don't know if it's going to help for me just to dive straight into what the court may regard as the gravamen of the decision under consideration, which is really, I would submit, paragraphs 34 and 35 of the judgment, and to look at those closely. And to do so in the context of the answer given to my Lord Justice's being question to my learned friend a few moments ago in relation to whether the really relevant question was that posed at the top of paragraph 28. 28, which is, would it make a difference? And that is a question which is, of course, extremely relevant and derived from at least two of my lords in the case of HW, when I think it was my Lord Justice Baker was addressing learned counsel, I think, for one of the parents in that case, and posed the question, receiving the judgment, as to whether or not a fact-finding hearing would be likely materially to affect the outcome, the welfare outcome from the child. Because if it doesn't affect the welfare outcome, then it simply doesn't really engage the question of necessity. And in that case, the answer from learned counsel, you have to concede, was yes. And it seemed that that decision in HW turned upon that answer. And it's the relevant question here. Of course, if it's not going to make a difference to welfare planning, risk management or outcome, then of course it would be regarded as an unnecessary investigation for a whole host of reasons. But if it does potentially shift the dial in relation to welfare outcome and planning, in this case for this child, then in our submission, it must make a difference. And so, just before looking at 34 and 35, the court is reminded of the context of this child, which is that the case, as managed by the learned judge, was tracking towards an outcome whereby the court was not contemplating the separation of mother and baby. And assessments have been conducted on the basis of them being united in a structured environment. And then the local authority's plan was to move on to a mother and baby foster placement. But at some point in the process, somebody was going to have to assess whether or not the mother's primary position, which is, I want to care for my baby by myself, was safe and viable.
I'm just pausing there, Mr. Bagchi. The position, as I understood it, was that the local authority's plan was effectively a step-down plan.
Yes.
From a residential unit to an 8-week mother and baby placement. And then, if that had gone well for consideration, then it would be given to the mother moving into her own flat. I think the mother's case was not that she wanted, as you've just emphasised, to be able to look after my child alone, but to look after the child, as she put it, with the help of various family members such as grandmother and aunt.
Yes.
But not resident.
Yes. The court will recall that the context in which the previous child had died had been in a similar family setting. We say that must be relevant. And so the relevant question is whether or not fact-finding in this case would be likely to make a difference to welfare outcome. And the real question, just diving into the detail in relation to this, would be the question of separation or not. So there is no separation at the moment, but one can well imagine that if the court had found that 7 years previously, the mother had played a role in the tragic death of the former child, then the question of whether or not it would be safe for her to look after this baby in a family setting would be safe or could be mitigated by other safety measures that could be put in place and established on a long-term basis. So, although the debate before the learned judge was conducted on the basis of the learned judge saying, well, was this a temporary loss of control type of scenario, like many other cases, and seemed to proceed on the basis that it was. In fact, there had been no factual investigation as to what it was, or indeed could have been, that brought about any behaviour on the part of the mother which might have led to the death of the child. There's a spectrum of possibilities there. There was a debate before the learned judge as to whether or not that was the most likely of the alternatives. But I can only say that must have been conducted on a theoretical basis, because at a fact-finding hearing, all possibilities would need to be considered, including the most serious finding, one supposes, of a deliberately and maliciously inflicted injury. And so, without those questions being answered, the central question of separation or not could not really be engaged with, because, of course, the reality is that for any party to advance a case in favour of separation, they would have to show that it was proportionate to the risk. And the assessment of proportionality of risk in this case, we submit, could not be properly undertaken by a risk assessor or the ultimate risk assessor, which is the learned judge, without knowing whether or not in reasonably similar circumstances, 7 years previously, a child of a similar age had suffered catastrophic injuries as the result of parental abuse. And so, just a few moments ago, my Lord Justice Peter Jackson asked the question of my learned friend as to whether it would mean that in every case there would of a child death, it would necessarily follow that there would be a fact-finding investigation. The answer is, of course not literally every case, but a case which is so aligned.
Every similar case.
Similar case.
Every similar case. Just thinking about the interim arrangements, as the judge would have to do. He operated on the basis that a 10-day fact-finding hearing, which was what you were giving the case, if you could get all the experts lined up, would take place in about a year.
Yeah.
So what was going to happen to the child in the meantime?
The mother and child would remain together in a mother and baby foster placement. That was the plan that the local authority advanced to the...
that was set up for 8 days.
8 weeks.
8 weeks, I beg your pardon. It was the supposition that you think the judge was working on, that the mother and baby foster placement would go on for a year.
Well, it would go on until it was complete, because there would be a process of assessment within that.
Well, how, on your theory?
Well,
and your theory is there can't be a process of assessment.
Well, there can't be a full process of assessment. There would be obviously useful information derived.
So during the period when the child is at most vulnerable, there's an assumption in the air of the court that the mother and baby are not going to be separated unless something truly troubling happens.
Indeed.
To justify it. So the mother and baby are going to be together for the next year under some protective canopy of some kind, whether that involves them being at home or whether it involves them being in local authority provided possibility. So during that period, separation isn't going to take place. So is separation going to take place if the judge then carries out a hearing in a year's time and finds that what happened in 2018 was as the local authority alleged?
Well, it may well do. It's possible to say, really. I can see that my lord might say, well, the wind is only blowing in one direction. But if there's if the most serious iteration of the possibilities...
I mean, of course, one has to read between the lines of some of this, but this is not a case in which the local authority set up to establish that this had been a cruel or sadistic killing. And the whole context of the case doesn't have that flavour. And so the prospect that there's going to be a finding of that sort is, one might think, pretty fanciful. So addressing the case that the local authority actually did put, which was encapsulated in the expression, a moment of madness, right, is that going to lead in a year's time, in the face of otherwise good progress, to a separation?
Well, it may do if the court makes a finding. We've had other cases, many cases, where the court is particularly concerned at the refusal of a parent to accept the findings or to offer any explanation.
Yes, but in a case where that's very often a case where the parent and the child are separated, the child is with the grandparents or the child is in foster care. We're talking here about a mother and child who've never been separated. So, I mean, doesn't the judge have to contemplate the reality of the case in that way?
I accept that, but in my submission, it's a step too far for the learned judge to have settled in his own mind on an outcome which results in the conclusion that even if the court makes a finding that it was inflicted injury, and no explanation is offered for the same by the mother, then it's still going to be an uphill struggle for the authorities, the local authority, indeed the guardian, to suggest that there should not be a separation between mother and baby shouldn't be contemplated.
I'm not for a moment challenging the idea that a guardian or a local authority might say, in the face of this evidence we've got about the first child, this mother and child should not be together at all. And this child should be in foster care and should wait there for a year in order that we decide whether it can be placed with mother. What I'm interrogating is the fact that the local authority nor the guardian has suggested separation now. If this is that worrying, there should be separation now. But to say that there should be unification now and then separation in a year seems to me to be a very peculiar state of affairs.
I respectfully agree with that. I think the reason for that is because of the way in which the case started. The court will have read the way in which the local authority had put its case initially, indeed before the guardian got involved.
Is now up to date and is on board and is taking a very active role in this, quite rightly. And so the guardian is not suggesting separation now because of the risks that arise from I mean, there was a big argument about whether the mother was on her own with the child for 32 hours a week or whether it was just 4 or 6 or 8 hours a week.
Indeed.
But the mother is on her own with this child for quite considerable periods of time anyhow. And that was part of the plan.
Well, it doesn't really change the reality that if the court finds that the mother inflicted the injuries in relation to a baby, albeit 7 years ago, there would be a significant, that would play a significant role in any conventional assessment of risk as to whether or not it's safe for her to parent this child without further safeguards, or whether or not there should be a separation.
Well, you couch this as a question of separation or not, and might it not be said that in fact there's a whole spectrum of possible, that may be the ultimate decision, but there's a whole spectrum of possible interim care plans that could be put in place pending a hearing.
Of course.
And similarly, afterwards,
Yes.
after a finding.
But they,
And this case would presumably be one where a resolutions type analysis would not be impossible
agreed.
in certain circumstances. That's the special way of assessing risk in cases of denial. We're looking down the track. It's not as black and white as separation or not.
No. Well, I agree with that, and I advance separation just to illustrate the potential range of outcomes and to make good the point that a finding would be likely to make a significant difference. But those,
and on an interim basis, just if I can just between, if it really does take 12 months to have a fact finding here, which is extremely depressing, if that's if it really does. But if it does, then along the way, the court would have to evaluate whether the interim circumstances cross the well-established interim test.
yes,
LNA test or whatever the recent case is.
which in this case, given where we are, would be a very
Well,
difficult decision.
Well, it would be a difficult decision, but that's what judges have to do.
Yeah.
Anyway.
I agree, there are a range of measures that could be taken following a fact-finding hearing, which don't necessarily result in separation, but do require a statutory framework and measures which can only be properly informed and justified by a finding of fact, because the degree of supervision, the location of any living arrangements, all those sorts of factors might be informed by the reality.
This is a case where there is I haven't got the full details in my head, but there is there is an extended family here supporting.
Yes.
I suppose it could be said that a decision following fact-finding, a finding, would assist in developing a plan of support, which everybody would have to accept.
Quite so, my lord. I enthusiastically adopt and endorse that. I mean,
sorry, I've just taken you where you wanted us to go to section 34 and 35.
Just because that's where the intense focus, as it were, of the debate this morning has landed. And just looking at them, I think it's about 6 lines down, paragraph 34. He says, in so doing, have struggled to identify why the care planning and risk assessment will materially change as a result of this finding being made. I made this inquiry of the local authority. Reference is made as to the potential for an adoptive outcome, and I questioned as to how the local authority's case, which would not otherwise support adoption, could become one of adoption as a result of finding as to events occurring almost certainly in mere seconds many years ago when the mother herself was a child. And in my submission, that's the learned judge, in a sense, jumping the gun, because it's right, as my Lord Justice Peter Jackson says, that the court has to have an eye on where it's going, but to come to a conclusion here and now that adoption, which of course means separation, inevitably, could not realistically be justified under any circumstance in this case, was, in my submission, a step too far. And of course, one can see on experience certain factors which would need to be backweighed in the balance in relation to that, including, I suppose, the passage of time and the fact that the mother was a child at that time. But it would all depend on the outcome of a conventionally conducted risk assessment based upon the findings of fact. And so that was a step too far. He says this, for my part, I remain unable to conceive of circumstances that would permit this marked change of direction. Whilst the case put before the court might be for placement, I cannot see this will have been set by any fact-finding. And what the learned judge is doing there, he's effectively saying, well, you might get your adoption, if that's what you're asking for, on other grounds which emerge from the process of assessment, but it's not dependent upon the result of any finding of fact in relation to what happened 7 years ago. And in our submission, that is, doesn't look very realistic on the facts of this case as being presented. And it's not the sort of case where we've seen in so many cases, HW, for example, or the Barnsley case, which we've referred to, which follows on from the famous Stockport case, where it all started, really.
You're losing me.
Right.
I'm afraid there, Mr.
All right, but
Chief.
essentially what I mean,
losing others as well.
All right. Essentially what I mean is when this element of the jurisdiction was developed in the Stockport case many, many years ago, it was done on the basis that there were significant concessions as to past behaviour. Threshold concessions were made, and there was an agreed care plan. And so there might have been an outlying element of fact-finding which hadn't been resolved at that time, but the court was indicated, I think it was Mr. Justice Thorpe as he then was, that it was permissible for the court to say there's no need for fact-finding these circumstances because there are concessions on threshold and the care plan is agreed. And we see that time and again in the decision in Barnsley, which I can take my lords to in a moment, that Mr. Justice Mostyn, in a much more modern context, reflected that similar approach. Concessions as to threshold, sufficient concessions as to threshold, and an agreed care plan. Therefore, no need to go through the exercise of establishing more serious facts. And the court may recall that was a case in where Mr. Justice Mostyn engaged with the issue as to whether or not it was relevant to consider the impact on any children, as yet unborn children, that might come along, as to whether or not there should be a fact-finding hearing for those purposes. We're nowhere near that in this case because there are no threshold concessions made by the mother at all. There is no agreed care plan. The comparators are between a fact-finding hearing and an alternative evaluation of facts which excludes fact-finding but has to take into account the mother's litigation position, that's the right term, on the other pleaded threshold grounds, which remain contentious. And so the notion that a risk assessment could be conducted on the basis that the assessor could in theory ask the mother questions about the circumstances of the previous child's death and then draw conclusions from her answers in relation to that, as the question as to whether or not she presented a risk to another child, is not only offside, Reby, but is fundamentally unfair to the mother, because those representing her would be correct to stand up immediately and say, well, that is flawed reasoning, because it cannot be held against her that she presents a risk because of the unsatisfactory answers that she's given in a risk assessment to questions relating to the previous death of a child, when at the moment the circumstances in which that child death are unknown and it's never been established how he died. So she'd be saying you cannot base any decision upon any conclusions drawn from that assessment, because classically that is beyond the pale. It's outside the consideration of any assessor, and indeed the ultimate risk assessor, which is of course the learned judge.
The mother's case, I don't want to dwell on unhappiness unnecessarily, but the mother's case is what on? We were taken to a passage in one of the reports. Something must have happened in the ambulance. Is that her case?
We at the moment we don't know, because she's not pleaded.
Well, she's not put a statement.
Yes.
But it's referred to in one of the reports we were taken to by Mr. Toomey.
Yes.
That her account is that she doesn't know what happened and the child must have suffered in the ambulance. Is that right?
Insofar as that she was putting that forward at any stage, she might have been putting it forward right at the very beginning, and maybe talking in those terms out. That doesn't seem to have been a matter ventilated in any way, realistic way, at the inquest.
To what extent could the decision about whether to have a fact finding be properly made without knowing precisely what the mother's case was in a statement?
It's difficult because, of course, the court has to assess the extent to which any factual inquiry would be necessary to build on any concessions made by the mother in relation to those facts, or indeed any evidence that she's given.
Well, your submission a moment ago was that the decision whether a lot turns on the exact concessions that are made. Is that case? But we don't know what the mother. We don't know the mother's. Know what the mother's case in submissions, but not what it is in.
But we know what she told the assessment.
Yeah, we know that.
We know what she told Dr. Van Velsen, and it was knowable, although it may not have been before the judge, what she said at the inquest. I think the judge did have the inquest transcript and had read it. Actually.
Yes, indeed, of course.
And so we have their accounts given by the.
So mother. you think that Millwall's right about that?
Yes.
So do you agree with what I said about statement? Do you think that was going too far?
It seemed the local authority had pleaded its case, albeit second time of asking. The mother had not been pressed on any formal threshold response to the pleaded case, though it is plain from the way in which the case has been conducted on her behalf that she accepted no role whatsoever in the circumstances leading to the death of the previous child. And that's entirely consistent with the way in which she gave her evidence to the inquest. The notion that there might have been something untoward happening in the ambulance was never pursued. If it were to be pursued now, that would be a whole different direction that the case might take in relation to that. But it doesn't. I'm sure if that was front and centre of the mother's defence, as it were, then we would know about it. So learned friend might be in a position to enlighten the court in a few moments. But ultimately, I do agree that it would have been much better, indeed necessary, for the learned judge to see effectively the mother's formal response to the threshold allegations, so at least he would know. Probably in this case it won't make a huge difference, but moving forward, before these decisions are taken, one can see how it would be useful for a judge to see the cases, I don't like using the word pleaded in the context of family law, but their cases set out formally in a document so the court knows the parameters.
As we're touching on this, the judge had before him the transcript, and it's in the top of the supplementary bundle at page 154. There's a page there that is, we need to read out for obvious reasons, but it's at page 154, 158 electronic.
Thank you.
Which is after some other passages which relate to the day in question.
Yes, they are germane, yes.
And
Okay.
and further up, we have it, for example, 151, we have a passage in which the mother's commentary in relation to the ambulance
Indeed, my lord.
appears, but clearly not necessary to read
No.
more fully, but that's the flavour of what the mother told the coroner.
Yes. Yes.
In 2022.
Indeed, my lord. And that's yes, and the
So we don't. I've actually. My point's a bad point. In this case, we have the mother's case set out in evidence.
provided it's confirmed that is her case, that remains the case. Yes, because that was her evidence, and nobody suggested in any way that doesn't remain her case. So, for the sake of formality, there probably ought to be a process whereby there is a formal response in advance of these Oxfordshire-type decisions being taken. May I move on to paragraph 35? Because this is the real difficulty that I think Guardian struggled with in terms of putting herself in the position of any risk assessor faced with a brief given to them by a learned judge's indications here. He says this: I accept for those working with a mother in the future, or those planning their ability to work with a mother in the future, that an answer to the question of this sort are bound to be helpful. By definition, such a conclusion will provide a court-based determination on balance of probability. But I do not understand why those working in such a setting would be unable to bring into their care and safety planning the prospect of a range of risk outcomes, including that which would be subject to fact-finding. And one stands back and asks oneself the question, what does that really mean? It can only mean, in our submission, that that if we limit the fact-finding to the pleaded case, excluding the allegations relating to 2018, notwithstanding that, the risk assessor can look at can survey the whole canvas, including the circumstances in which the previous child died. And the point I've made before, I'm really just underlining it, because we see it in these passages, that any conclusions drawn from that part of the assessment would be bound to be controversial and are just essentially, in a re-B sense, offside. Because that assessor might be holding the mother's response to questions relating to that against her and informing a conclusion which militates in favour of an outcome she's not happy with, because the assessment of risk in those circumstances is higher than it might have been if the circumstances of death were excluded from consideration of the risk assessment. And that's the problem. And that's the difficulty which the learned judge, with respect to him, cannot satisfactorily address by his reasoning. We go on. I consider and agree with those acting for the mother that the risk planning is focused on what it is that causes the risk here of impulsivity. The question of how that may play out should not be limited only to those outcomes which have been established to have previously arisen as a result. So I think that's the point we've made in writing. The judge has limited the investigation to the risk of something happening, not the magnitude of the gravity of the outcome if it happens. And to put a very simple point, is that there might be a high risk of something quite trivial happening, and that might balance in a certain way, or there might be quite a low risk of something catastrophic happening. And when my lord was asking my learned friend the questions as to risk assessment in a human context rather than a formal context, of course, if you're making plans for a child as a parent, everybody has a different tolerance of levels of risk. And some people might take more risks with their children, some people might take fewer risks. And to leave it to an assessor to make a risk assessment in a vacuum, as it were, is singly unhelpful, would lead to inconsistent and unfair results. And so where we end up is, in reality, with a risk assessment which leaves the mother exposed to unfairness and just buying into problems down the line in relation to welfare planning. If the local authority said, well, we commissioned a risk assessment on my lord's basis, the learned judge, and it's suggesting that the risk assessor is extremely concerned about the mother's answers to questions about what happened. And in those circumstances, the advice is to effect a separation or stringent monitoring measures, which the mother's not happy with. All the more so in this case, because the court's already read that she has difficulty engaging with certain professionals. And then we're stuck, really, because the whole process has begun on a false footing at the outset.
So, are you saying, therefore, that the letter of instruction to the assessor will be on the basis that he or she is not limited to considering outcomes which have been established to have previously arisen?
Yeah, that seems what the learned judge is saying. You can look at the full panoply of risk based on the notion of brackets unadmitted impulsivity. And there's a whole range of essentially what we're saying is that the risk outcomes are so far apart in this case, from the lowest end of the spectrum to the highest end, on the facts of this case. I think they've used the word in the skeleton, not fudge. You can't accommodate that unless you establish what happened.
Sorry to speak over you, but could I just say that my reading of the question that my lord has just read is not as refers to the deceased child, but as referring to any outcomes that may have occurred in relation to this child. What the judge is, on my reading of this, which may of course be incorrect, is saying that the assessor and the assessment would not be limited to things that had been experienced by this child, but would include all possible risks that might result from impulsivity.
Yes. So
I had thought at one stage that we were reading that as saying that it was outcomes that had previously arisen, was referring to an assumption about what had happened to the child who died, but that's not what he's referring to, as it seems to me. He's considering that you don't just look at what happened in the assessment centre and what's happening in the community, but you consider the extent of the mother's impulsivity and consider all possible outcomes of that.
But
That's my reading of it.
I mean, it's
It
not.
may be
It
honest.
is not.
It's not.
I think we can agree on this. It's not straightforward. Not be limited only to those outcomes which have been established to have previously arisen as a result.
I'm gaining from this that the judge would not say it would be short-sighted in the extreme to ignore, it would be short-sighted not to consider the potentially catastrophic outcomes of impulsivity. That's the reading that I have so far placed on this paragraph.
Would it be, to be fair to the judge, Mr. Bakshi, we focused on, both you and Mr. Toomey, focused on those two sentences, but perhaps we should read to the end of the
Yes.
paragraph,
And so we go.
because there's a sentence beginning put simply, which may help.
Yes. Put simply, it's most unlikely that any care planning would be structured simply to guard against future risk of shaking, given any future risk would, on balance, likely to arise in a different way. But risk planning would have to regard to risk including loss of control and conduct towards a child, including by shaking, without such findings being made. But the mother says there was no shaking, and the court hasn't found that there's any shaking. So how could a risk assessment
So this is a forbidden topic. I'm
It's
not
not-
going to answer any questions on it.
Yes, and the interpretation of her answers in relation to it can't be held against her.
Yeah.
And that's the system which we all operate with quite successfully, if I may say so.
Well, that's opening up a whole range of issues to say that. Yeah.
And so shaking's not really on the agenda by the time we get to risk assessment, frankly, because it's unless they
But the
find-
judge is, are you saying the judge is proceeding on the basis that it is?
Well, it looks as if
He is,
by
isn't
that he's authorising any future risk assessment to look at the full range of risks, including what happened in 2018.
Yeah. I mean,
Otherwise, why mention the word shaking?
I'll have to go and read this again. But at the moment, I think that possibly, and supports my interpretation of what he meant by outcomes which have been established to have previously arisen as a result.
Yeah.
I mean,
Yes, I think you're probably right.
I mean, it's not clear. I think he is.
And that's the fulcrum of the decision, really. Paragraphs 34 and 35. Everything else is like it sort of feeds into that. And it's not the case, and I underline that we simply move from the death of a child into an automatic fact-finding process. It all depends on a range of factors, concessions and the like. But in a case like this, I've said this before, but it's the facts are so aligned. It's only 7 years. That the mother remains young in age. Some of the background wider campus concerns remain. We've pointed that out. We've said they've been put slightly more intense focus by the recent assessments. Back in 2018, there wasn't an assessment by someone like Dr. Van Velsen, extremely experienced forensic psychiatrist. And against that background, there's quite a significant alignment between the circumstances which prevailed then and those that prevail now. Because, you know, the notion that this child should move back into a family setting, I think somebody was suggesting maybe in the same accommodation with a baby in circumstances, given what happened in 2018, it's so closely aligned as to I think, present to the Guardian quite a startling notion that you wouldn't at least try and find out what happened.
One unusual feature, factual feature here, is that unlike many cases where a family court is investigating the death of a child, here we've had an inquest.
Yes.
I mean, because 7 years has passed, there's
Yes.
been the inquest. Ordinarily, thinking back to cases we've heard, Lord and I have heard, where there is a sibling who is the subject child, a living sibling. So that's
Yes.
why you have the fact-finding hearing into the death of a child. That will be before an inquest.
Indeed.
So it will be, and it will be before any criminal proceedings. The
Yes.
family court is the first forensic investigation. But here you've got an inquest. One would hope that there might be ways in which the scope of a fact-finding hearing in the family court could be narrowed by the outcome of the inquest, by the evidence in the inquest, by the conclusions of the inquest, even if not necessarily binding.
Yes.
Think about that. Surely the scope of the inquiry would be narrowed, and I'm just wondering. It seems very depressing to think it's going to take 12 months to have a full 10 and then have a full 10-day hearing.
Yes, well, it would depend on the litigation position taken by the parties. You will see there was an evolution in the body of experts from their paper consideration to the position they ended up in when they were hot tubbing, I think, all together in the witness box, when they sometimes said that...
Mr. Carey moved his position, and
Yes.
Dr. Al-Sarraj moved his position.
Right, so... And so, yes, if the mother's litigation position is that she accepts the broad thrust of the advice given by those very well-known experts, that this was a case of inflicted head trauma, then that answers the first question, which is was causation. The next question is whether or not it can be established on the local authorities pleaded case that the mother was the perpetrator. The case could be limited simply to that aspect, but that would require significant concessions made on behalf of the mother's team. And one knows from experience that, perhaps it's a point made in the recent consideration by my Lord, Mr. Justice MacDonald in the experts case that sometimes, particularly shaking fact-finding hearings, having the experts physically present to give evidence in the courtroom does offer very valuable insights as to the extent to which it is the possibility that an unknown cause becomes more into focus.
And Mr.
So I'm
Tyler will be quick to remind us if it's the case, the mother would not have been represented at the inquest. No. I thought he's shaken his head.
Yeah.
So that's the position. And so Mr. Barnes has shaken his head as well. So the
So-
mother wasn't represented in this process, which is a fact.
But one could imagine, and not criticise the mother's team if they took the view that they wanted to challenge the forensic medical evidence as to whether given the slightly unusual profile of injuries in this case.
All right, well, it's probably not helpful to speculate on
Yeah.
what might happen, but anyway, there might be scope for narrowing,
Yes.
the opportunity to narrow the scope.
Yeah. But I wouldn't lean into that personally too heavily, having
Thought about it.
probably sat through 5 shaking cases this year already, and knowing the way in which the issues do play out when the experts are actually in the room or in the virtual room. My Lord, I note the time. It's 15 minutes or so. I don't think, unless I can be of any further assistance, that there are any further points. I've made quite long-winded and I hope clear submissions, but they all come back to the same point, really. Yeah. And I think between us, we have made that point several times.
Between you have. Thank you very much, Mr. Banks.
Before I sit down, I think in fairness to the learned judge sitting in the court below, and in view of just one or two observations by my learned friend, Mr. Tyler, in my concluding observations, which my lords may have read, this was not in any way designed to criticise this judge for having bowed down or overly absorbed any guidance in relation to keeping cases short. He specifically eschewed those factors when he came to conduct his own personal balancing exercise. What I was seeking to do was just to, this court doesn't read rewinding actually, but just perhaps to underline the circumstances in which the family justice system is operating at the moment. And the fact that we've had decisions recently in a number of cases which are I think, possibly been held to have gone a little bit too far in relation to the compression of proceedings, particularly at first instance. And the concern within the wider profession is that there may be guidance in relation to keeping cases short. I think it's the point that my Lord Justice Peter Jackson made in some observations made in HDH, but the principles are the same, and we haven't had a change in the law. And the guidance from the higher courts in relation to the application of those principles is very clear and well set out. And there's just, I think, probably a fear within the wider profession that there's a chilling or dampening effect on judges at first instance in feeling pressure to keep things short, for reasons which are entirely understandable and to do with the pressures on the lists and cost and the like. And so it was just a nod to the current context in which these decisions have been taken, but it was in no way a criticism of the way this learned judge approached his task. I wanted to make that clear.
Thank you very much, Mr. Bagtree. It was not out of any disrespect to Mr. Archer or Miss Hudson that I didn't call on either of them. It seemed to me that as Mr. Toomey and Mr. Bagtree were essentially fighting from the same trench, that having 4 counsel address us for the appellants might be excessive. But, if in due time, Mr. Tyler, you want to leave anything to Mr. Barnes other than taking a bow,
Thank you.
it'll be fine. Would you like to make a start?
Indeed. Well, my lords, I wonder if before I dive into the detail of our case, I could step back slightly and make a few preliminary points ordered into 4 topics. The first, parameters of the appeal, and it's perhaps a point too obvious to make, but the question for this court is not what would we have done. It's not what would we have done having heard 7 hours of submissions from extremely experienced leading counsel. Was what Judge Willans decided to do wrong. This is a case management decision under appeal. It's an important one for sure, but it's a case management decision, and my lords know what that means in relation to the height of the hurdle to be surmounted in challenging it. From paragraph 23 of my Lord Justice Peter Jackson's judgment in HDH, 2 observations which we say have resonance in this case. First of all, quote, "These are not always easy decisions, and the factors typically do not all point the same way. Most decisions will have their downsides." And secondly, the reasoned case management choice of a judge who approaches the law correctly and takes all relevant factors into account will be upheld on appeal unless it has been shown that something has gone badly wrong with the balancing exercise. If this court repeatedly warns itself in judging...
Sorry, Mr. Tyler, were you going to give us the 4 points, as it were, before breaking off, or are you going to develop number 1?
I was going to give you the 4 general points first, and then develop in due course.
Well, those are the first point.
That's point 1. That's parameter of the appeal.
Yes.
That's almost point 1.
Yes.
It'll soon be point 1 when I finish it. So the end of that preliminary point is this. If this court repeatedly warns itself of the dangers of a, quote, close textual analysis of a judgment, rather than standing back and looking at the judgment as a whole, then given quite how much attention has been paid to 2 individual paragraphs in this case, and quite how much attention I will need to pay to those in a moment, then it may be that we're quite close to falling into that trap. And I note in passing that if any part of those paragraphs or any other part of the judgment are not immediately easy to understand, there were no requests for clarification made, which could have been made and arguably should have been made. Preliminary point 2.
Clarification on... Do you have clarifications of this sort of decision?
Well, for example, my Lord has engaged in dialogue with my learned friends in relation to what exactly was meant by a particular sentence or question or phrase in the judgment. If there is ambiguity about something like that in what is a closely reasoned judgment, then that could easily have been dealt with. General point number 2. This judge in this case, an extremely experienced circuit judge, acting designated family judge in the busy London court in which he practices, sitting in this case at the level of Deputy High Court judge. A judge who was extremely and intimately familiar with this case. In fact, this case represents a paradigm of appropriate judicial continuity. Judge Willans has presided over every hearing in it. The hearing itself was very carefully set up. Skeleton arguments, senior, junior for the local authority, silks and juniors for mother and guardian. We see from the transcript that propositions were entirely appropriately explored and tested in exchanges between bench and bar. The middle part of paragraph 23 of HDH, Lord Jackson's judgment said this: however, the court should be able to make its ruling quite concisely by referring to the main factors that bear on the individual case and identifying where the balance falls and why. In this case, of course, we have a reserved judgment, a detailed, careful reserved judgment, a judgment in relation to which is clear that the greatest judicial care have been applied to reaching the decision. No issue is taken that the identification and exposition of the relevant law was done anything other than correctly. The transcript, to parts of which I'll take my lords after lunch, demonstrates that this case was approached in an entirely appropriately case-specific way. I'm grateful to my own friend for the Guardian for effectively decoupling those comments about possible difficulties in the family justice system generally with the approach taken in this case. It's clear that the judge was absolutely case-specific in this case and paid little, if any, regard to broader difficulties, resource issues, or trends which might be coming on high. General point number 3, some particular features about this case. My lords know them all, but just drawing them together we think is perhaps important. First of all, the death of the older child, 2018, so a full 7 years before any fact-finding hearing would have taken place. It occurred when the mother was just 16 herself, a child, and my lords know something of her history and where she was at that stage. She's now an adult. The court below knows a lot about her. It knows a lot about her life and how it's changed in those 7 years. With reference to that, an important feature of this case is that the mother has been living in the residential assessment unit with the child for 6 full months now. She moves tomorrow, as my lords have heard. Not only is that, of course, an extremely claustrophobic environment, which most young mothers find difficult, but also, relevance to this point, it's very highly monitored. In consequence, the court below would have had, at the IRH stroke early final hearing, which would have taken place this Friday just gone, were it not for this appeal. And it will have, when it comes to make the final welfare decision, an extremely full repository of very detailed data about how this mother operates and functions now, in particular, how she does so in relation to parenting this baby now, and also importantly, in the context of, by then 6 months, by now 6 months, by then more than that, of extremely stressful and challenging circumstances. On top of that, and as my Lord Justice Jackson pointed out earlier, there's far more evidence as well. There's a vast amount of evidence about this mother. You've got Dr. Van Velsen's 2 reports, but also the extensive library of the further evidence from all sorts of different sources, going back deep into the mother's childhood. Much, of course, was lived under the gaze of professionals. So the court, when it comes to make a decision, will know a vast amount about this mother, about her parenting of this child, and an awful lot of that will come from professional observations, sources, and assessments. This isn't a single issue case. The threshold existed and was pleaded by the local authority in the first instance without seeking to demonstrate responsibility for the death of the older child. Whilst much is made of the absence of concessions, my Lords will note that the initial interim threshold document resulted in the mother's response accepting interim threshold was made out, and of course there hasn't been yet a response to the final threshold document. The fact in any event of there being no or limited admissions, which seems to be relied on by authority and guardian alike as reasons why the quote approach shouldn't be taken, is neither here nor there. There are pleaded findings sought. If denials are maintained, and if it's relevant and necessary, they can be litigated in the usual way. But the usual way for those wouldn't necessitate a fact-finding hearing many, many months hence. It probably wouldn't necessitate even any sort of split hearing. In relation to denials, and my Lords may already have this point, but for example, the mother's not accepting the degree of emotional dysregulation which is put at her door. You may have noted that even in the local authority's most recent statement, the authority itself points to the fact that some of the recent observations, that some of the recent conclusions drawn at the residential centre aren't in fact borne out by the underlying observations from that centre.
Can I ask, you mentioned the concessions, does the mother, is it accepted, that's the point I put to Mr. Toomey, is it accepted that the mother's impulsivity could lead to the death of the child?
Well, not a question you'll appreciate that I have put, but certainly when I come on to look at the judgment, we will accept that if impulsivity is demonstrated to the degree it's asserted, then the approach taken by the judge, quite rightly, would allow for that to be one of the possible outcomes. And that is how we say those rogue paragraphs of the judgment should be interpreted, can only be interpreted in the broader context of that judgment. We say that those paragraphs demonstrate that the judge was trying to widen out the range of possible adverse outcomes from impulsivity rather than narrow them down or exclude anything. But I'll come to that if I may when I look at those paragraphs in more detail. I could probably just fit in the fourth point before you asked me to raise, yes, which is this. The shape of the case with and without the fact-finding hearing contended for. As I've indicated, and as my Lords will know, the order of the 28th of May listed the IRH early final hearing on the 4th of July, so this Friday just passed. It was entirely conceivable, had that gone ahead, that a final order and decision would have been made. It's entirely conceivable, this isn't a concession, but simply an observation about how these things happen, that concessions in relation to threshold would have been made in a way acceptable to all. And given what we read in the statement about the care plan at that stage, entirely conceivable that there would be agreement between the parties approved by the court as to the way forward. The proceedings were issued on the 20th of January, just 5 days after the child's birth. So they would have concluded, if they had concluded on Friday, within the statutory 26 weeks. Even if there had to be a short final hearing, that could have been accommodated presumably relatively quickly and relatively shortly after the expiry of those 26 weeks. If a fact-finding hearing is to be directed, then with the greatest of respect, I'm not quite sure that the fact of the inquest makes things simpler, but rather more complicated. The previous experts will need to be re-instructed. There will need to be the fresh instruction of new experts. We'll also have seen that as at May, before Judge Willans, Mr. J.M. Owen, who's the neurosurgeon preferred by the local authority, was to be reporting as late as November. We don't know whether that date holds or whether that's now 6 weeks on as well. It was proposed, but of course no decision was made given the principal decision that a paediatrician would be instructed. He or she would have to be one of the top drawer of paediatricians, of whom there are relatively few, given the difficulties in this case. In any event,
what in this case?
Given the medical difficulties in this case, the evidential difficulties.
It was either Dr. Cartledge or Dr. Rose.
Indeed. if they could report in time, certainly would expect it to be a few weeks after Mr. J. Moen's report came in, thereafter experts meeting, etc. You may have seen the difficulties in relation to Professor Mangum, and I'll say some more about that in due course, but it may be that my lords have noted for the transcript what was proposed as a possibility in relation to dealing with that problem, but it was certainly added to rather than reduced the issues with the expert evidence. I'm not sure whether the 12 months set out, referred to by the judge, were before the fact-finding hearing could take place or before a final conclusion could take place. But either way, just looking at the expert evidence, it looks unlikely that the case will be ready very much before Easter for fact-finding. And assuming facts to any degree were found, there'd be no point in having found them unless there would then be an assessment, which would then take a large number of weeks, followed then by the usual evidence gathering, etc., etc. So the binary choice with which Judge Willans was faced was, we can finish this case within or very shortly outside the 26 weeks in relation to a child whose proceedings were issued shortly after her birth, or we can add at least a year, probably more, to the process, and in doing so, of course, add not just uncertainty for the child, but ongoing artificiality for the person who currently is charged with looking after that child. And the prospect, I'll conclude this fourth point here, the prospect of well over a year in a mother and baby foster placement is an unattractive one for any young mother. It's also probably an unprecedented one in the experience of any experienced care judge or care practitioner. So, my lords, I'm sorry to have kept the court beyond 1 o'clock, but those are the opening observations I wanted to make.
Thank you very much, Mr. Tyler. Mr. Tyler, we are going to need to finish the hearing by 4 today. Do you think there will be any difficulty in that?
No, depending on
Well, of
how
course,
much
it
is asked to be
depends how
found.
talkative we
For
are.
my part, no.
Right. Shall we resume at 2 o'clock then? Yes.